Everybody, so we're going to look at the final part of your contract law unit, and this refers to how contracts can be brought to an end. So we've spent time through the unit looking at how a contract is formed through the four main elements, starting with the offer, moving to acceptance of that offer, establishing the relevant intention to create that legal agreement, and then identifying what the consideration is as part of that contract. We also looked at who can be party to a contract and therefore can enforce the rights under a contract. And we looked at those rules under the privity of contract, the idea that a contract is generally made between two parties, but the Contracts Rights of Third Parties Act 1999 did seek to widen that somewhat, allowing anybody who is set to benefit from a contractual agreement to be able to also enforce their rights. We then moved to looking at what would make up a contract. We looked at the categories of terms that you would find in a contract, starting with the most serious down to the least serious. We then looked at the rules for what could be deemed to be a term within a contract, so how those terms can be expressed. Are they clear? Is there a presumption that you've read those terms in order for them to be enforceable? Harsh terms have to be made clear. That was an important rule that we looked at in class. And then, of course, those terms that you may not see but could be implied either through court rules, so looking on the facts, is it necessary? Is it custom and practice for a term to be included? Perhaps based on a reasonable bystander or person, should a term be included? So that objective view or whether a term can be included. Or have Parliament legislated for terms to be included? And we spent some time looking at, in particular, the Consumer Rights Act 2015, where as a consumer of a product or a service, or perhaps digital products or services now too, you can be protected through rights given to you in the Consumer Rights Act by Parliament. So a contract is made up of a whole number of terms, not just those necessarily that we can see in the document itself. We then moved to looking at things that could void a contract, potential vitiating factors. Perhaps the contract offeror or maker misrepresented the situation, maybe innocently, negligently, or even fraudulently. We looked at the effect of all of those as potential outcomes. Perhaps you've been forced into entering into a contract, so perhaps economic duress is a factor there that could void the contract. And of course, there are other factors that could void a contract that are outside of this specification, such as duress itself in its raw form, or undue influence or pressure. So we looked at those, and what we're going to go through now is how your obligations under the contract can be discharged. So ways in which a contract can be brought to an end. So you've got the three circumstances on the first slide here. So circumstances under which a contract can end could be through performance, could be through frustration, could be through breach. So we're going to go through each of those in. So in terms of performance, this is luckily one of the most common ways of bringing a contract to an end. Usually both parties fulfil their contractual obligations, the terms of the contract, the agreement. I will sell you this product in return for money. You sell the product. That product is of satisfactory quality, fit for purpose as described. It meets all of the implied terms as well as the express terms. And you receive payment again according to the express and implied terms, and then the contract ends naturally. And that should be how most contracts work, and it should not be any more complicated than that. However, what happens where a party is claimed to have not performed their contract as expected? You have the right to claim damages if you are the victim of non-performance. So you, in an action through court, become a claimant, claiming damages. These damages can be for loss of profits. You could also claim for physical damages. And at the end of term, we spent some time looking at what you can claim for and the different types of damages. So we know we have general damages, we have speculative damages, and those damages can be financial, or in other words, pecuniary, or non-financial, more difficult to quantify, in other words, non-pecuniary. Okay. We also looked at court orders that could be made for certain issues as well. Perhaps an injunction would be needed, or an order for specific performance. So if somebody is not performing their contract, the main remedy would be damages, but there could be instances where you want to enforce specific performance. Of course, that's down to the claimant to ask for what they feel is right for them. So many contracts hinge on payment. Of course, you provide a good or you provide a service, and that is dependent on payment. Okay, but of course, the person who needs to pay for that good or service is not going to pay unless, in their minds, performance has been completed. There have been many court hearings and many fallouts where people have argued that they have performed either the contract substantially, or they believe that they should be paid for what they've done. Perhaps they're admitting they haven't performed the full contract, but they performed part, and they should be paid for that part. So there are rules that have developed over time, again through various court decisions. So this is a common law area, as most areas of contract are, and the courts have made a decision really case by case. But I've managed to put it into a number of hopefully straightforward rules that you can follow. So go through these and then make sure, as always, that you summarise these rules at the end, and you have case examples for each principle that will be on this slide, but make sure you do spend time summarising these. And don't forget, there is a worksheet that I've given you to help with this as well. Okay, so a key case in this area is Cutter and Powell. Please note that many cases, landmark cases, are old. So this is from 1795. So this is where the claimant's husband contracted to work as a second mate on a ship to Jamaica, and the voyage was set to last for 8 weeks. 6 weeks in, the husband died, and his wife sought to claim money for the work he had carried out. So it was held that the contract had not been completed. So the payment for him working was agreed based on him working until they reached Jamaica. So he had not performed the contract. Now, that on the face of it seems to be very unfair, and there are other areas of contract law perhaps that we could seek to use here, and certainly the claimant's husband could have argued that this was well out of his control. It does seem unfair, but that's the basic rule. Okay, so payment usually cannot be claimed for or enforced by the claimant unless the performance has been completed. So unless they have performed their obligations and therefore discharged their obligations under the contract. The other point to make is that their performance must be what they're contractually obligated to do. So it must be exact, as specified under the terms. And you've got another key case here, Moore and Landauer. So a contract for the sale of 3,100 tins of peaches described the tins as being packed in cases of 30. But when they arrived, they were actually packed in cases of 24. So even though the right number of tins, and you could do a bit of maths and work out, well, how did this equate to that? But the right number of tins arrived, but actually performance had not been exact or as agreed. So therefore, the claimant was entitled to reject the goods and ask for a refund, or perhaps to amend that and pack the tins of peaches correctly. So we have to look at whether performance has been completed and what the obligation was. Have they actually carried out what they've been asked to do? Okay. So there are exceptions to where you could, as a claimant, claim for non-performance. But base your claim on the idea that you have still performed an amount of the contract that is evident. So I'm going to explain this to you now so that this hopefully makes more sense. So perhaps a contract hasn't been fully performed, but a court can divide the contract into separate parts and say, well, this part has been completed, so therefore this part can be paid for. Yeah, and we'll have a look at an exam scenario in a minute. But perhaps you contract to supply two goods. You supply one and not another. You could claim for payment of the one that you've supplied, but you can't claim payment for the other. So you haven't fully completed performance of your contractual obligations. You can't fully discharge the contract. You're technically breaching part of it, but you have performed the other part. So, of course, this will only be evident where a contract can be divided. Okay? Secondly, perhaps you could claim that you have substantially performed the contract. So, by and large, you've performed as much of the contract as you can. So, you could claim for the performance of the work you've done, minus, and so we take off the work outstanding or the work that needs fixing, perhaps. So, this could be, in a building contract, you contract with owners of a house to build an extension with an additional patio terrace, for example. You complete the extension, but you don't complete the patio terrace. You could technically ask or claim for payment of the extension. And of course, you wouldn't be able to claim for the work to the patio terrace because that is the work outstanding. Okay. However, if the people who you've carried out the work for can prove or show the court that they haven't actually benefited from the work that you've provided, so perhaps you have built the extension, but it's not fit for purpose. Maybe it's not satisfactory quality. Maybe it's dangerous. Perhaps the roof is leaking, perhaps the electrics aren't completed, all kinds of things that can raise safety issues, then your claim for substantial performance will not be successful. So you really have to look at what's been completed in order to try and claim for what you've carried out. If you're going to claim for substantial performance, then the work that you've carried out has to have benefited the other party. And of course, we have to be able to identify what that work is. So there are some cases here that can support those points that I've just gone through. So have a look at these. So you've got Ritchie and Atkinson, Taylor and Webb, Honig and Isaacs, Sumpter and Hedges, Bolton and Madeva. Possibly not saying those correctly. So please pause this now and see if you can match these cases to the exceptions over the page, please. And hopefully, by and large, they are obvious to you. Okay, so hopefully you've done that. So the first one, hopefully you can see that the contract could be divided. So the claimant could claim for the part that was performed. For Taylor and Webb, hopefully you can see that there couldn't be a claim for performance here because the performance was not exact. Okay. For Isaacs, hopefully you can see that the contract had been substantially completed. So the claimant could claim for what had been completed. Hopefully you can see with Sumpter and Hedges the opposite. You couldn't divide the contract and there was insufficient work done to support any dividing of the contract or any substantial completion. So breach there. And then the final one, again, no substantial performance there. Okay, so do take some time to read through the facts of those. You can always go on to e-law resources as well and have a look at these. And in your textbooks to make sure you understand them and you can support your principals with as many of these cases as possible. There could be an instance where you could claim that you've tried to perform a contract or you've offered to perform your obligations under a contract, but you've been prevented from doing so. In which case, if you're unable to perform your contractual obligations, as we've looked at on previous slides, you could technically be in breach of your contract terms or obligations. But if you're unable to perform because you're being prevented to do so, so you've tried to either offer to perform and that's been refused, or you've been unable to perform, then this could enable you to actually sue the other party for non-acceptance of your performance. And this part, arguably a small part of performance, is referred to as tender of performance. So if you tender for something, you're offering something, and it is something you see quite frequently with contractors for building works or perhaps suppliers of services, where you might tender for the contract, you want to win the work, and you could do that through a written-based application or in an oral type of pitch. And you're offering performance of the contractual obligations. But if these are refused, then you can't be at fault for being unable to discharge your obligations and therefore complete your end of the contract, so to speak. So in this instance, you're not at fault. If you're unable to perform, then that comes under a different area called frustration that we'll look at in a little while. So the tendering of performance is really well explained in this case, Startup and McDonald. So this is where Startup and McDonald had a contract. Startup was going to deliver oil to McDonald, and the contract stated that that oil had to be delivered within the last 14 days of March. Now, Startup turned up at 8:30 p.m. on the last day of March, but McDonald refused the delivery and said they were late. Now, it would be important for a court to look at what was agreed, and in this instance, the term of time performance was simply within the last 14 days. Had there been a specific time stipulated, then of course, yes, Startup might have been in breach. But the fact that they turned up and tried to perform their part of the contract within the agreed time, then they were not in breach. And in actual fact, they had tendered performance, they tried to perform their end of the bargain, and they were entitled to damages from McDonald for non-acceptance, so they could bring an action against McDonald. So it's worth just keeping an eye out for that in scenarios. Now, what could happen as well, again, a potential small instance to look out for in scenarios. It could be that a party makes it clear to the other party before performance is due that they are unable or unwilling to perform their contractual obligations. So, I'm going to be unable to do X. And this is really clearly set out again in this case, Hoxter de la Tour. What happens if you say that you can't undertake a role or you can't perform your contractual obligation coming up? Okay, so Hoxter had agreed to be a courier for de la Tour, which was due to start, so the role was due to start in June. On the 11th of May, Hoxter said that they could no longer undertake the role. So they'd put de la Tour on notice of being unable to perform the contract or unwilling to perform the contract. De la Tour was able to find another courier, but one that couldn't start until July. So, of course, what they have is the loss of a courier for a month or so. So they successfully sued Hoxter in anticipation of the loss. So if you know that somebody is due to breach their contract beforehand, so if you can't perform, remember the effect is that you've breached your contractual obligations, you've broken the terms of the agreement, then that's what we call an anticipatory breach. You can end the contract by suing somebody in anticipation of them breaching it. So if they tell you, I'm not going to be able to perform, then they are in breach. And in terms of what the effect of a breach of terms means, what is the effect? If you remember, we looked before at the categorising of contractual terms. And in essence, it comes down to how important that term is. Is it a condition which in essence goes to the root, the fundamental purpose, the core of the contract? If you breach a core fundamental purpose, so in this case with Hoxter and de la Tour, agreeing to be a courier and then no longer being able to be a courier is of course going to be a breach of the fundamental purpose of the contract. If they said, I can still be a courier, but perhaps I need to slightly amend the hours or use slightly different equipment, different transport, then that may not be a breach of a condition, but instead a breach of a secondary term of the contract, a breach of warranty. So depending on what has been breached leads us to the outcome of what the breach would be. So hopefully this is ringing some bells. And I've got a little slide here. I'd like you to pause this recording and see if you can have a read through it and fill in the gaps. I've given you the 3 key terms at the bottom. So please do pause and try and do that now. So hopefully you found that relatively easy. And remember, the effects of a breach of contract depends on the seriousness. If you breach an important term, such as a condition, then this can result in repudiation of the contract. And remember, repudiation means that you are entitled to bring the contract to an end and sue for losses. Now, if you can perform the contract, but perhaps you fail to perform on time, or you fail to perform to the adequate standard expected, then this could be considered to be a breach of a secondary term. In other words, a breach of a warranty. And the effect of this could be rescission. So you're entitled to rescind the contract. This doesn't automatically allow the contract to end, remember. This enables you to sue for losses for that failure, but the contract doesn't necessarily end, it could continue. And as I've just covered with you, you can sue in anticipation of breach at any time before performance is due. But of course, as the party suing in anticipation, you have to bring evidence to show that the other party made it clear that they are unable or unwilling to perform the contract. Now, if somebody becomes unable to perform a contract out of their control, then that's where we can go on to our next topic of frustration. Okay? But first of all, I'd just like you to look at a typical OCR scenario. And I want you to pause this in a minute, please, and read through it and see if you can identify the issues of performance here. Okay? As an additional challenge, see if you can identify whether this would be, any potential breach would be of a condition or a warranty. So the question is, advise whether Lewis can claim any money from Jill, Sanjit and Cynthia. So as always with OCR scenarios, there are often 2 or 3 issues, incidents to consider. So here we've got 3. So the best thing to do is to separate out the parts of the scenario. So the issue with Lewis in relation to Jill would be the first one, and then Lewis and Sanjit, and then Lewis and Cynthia. Okay, so please pause and see if you can identify what the issue is and whether Lewis can claim any money. Okay, so the first one in relation to Lewis and Jill. So he's made a contract with Jill to build a garage. The contract specifies individual prices for the walls, roof and windows. He builds Jill's garage wall and roof, but he doesn't install the windows. So the question is, can he claim any money? I mean, could this be a claim for part performance? Could the contract be divisible? So that could be something that you could consider. Can he claim for the garage wall and roof? So I guess, yes, the contract could be divisible. However, if you think about building a garage without windows, then it may be that he can't claim based on there not being any real benefit gained, because if you've got a garage without windows, it's not really fit for purpose. So this could come under one of the exceptions. So do feel free to go back to your performance slide and have a look at that. In relation to Lewis and Sanjit, so Lewis has a contract with Sanjit to fit a new kitchen. He completes most of the work, but he doesn't install handles on 2 of the cupboards. So we have to consider here, is this substantial performance? So he hasn't installed 2 handles, but actually in contrast to the situation with Jill, this kitchen is going to be largely fit for purpose, isn't it? There's going to be a significant benefit to Sanjit. It's all completed minus the 2 small snagging issues. So Lewis could quite rightly, I'd say, clearly claim for substantial performance minus cost of installing 2 handles. Hopefully you agree with that. Okay, then the final one. Lewis has a contract to install new lighting in Cynthia's garden. The work is expected to take 4 days, must be finished by Saturday, the 11th of July, in time for Cynthia's birthday party. He arrives at Cynthia's house to start work on the lighting on the 10th. Okay, she turns him away. Now, the question here is whether Lewis could claim that he's tried to perform the contract and, sorry for my typo there, but has been refused. So hopefully you've considered that point, but of course, has he already breached his contractual agreement by turning up late as it is? Okay, so Cynthia could argue that he's unable to perform. She could sue him for anticipatory breach. It's unlikely that Lewis is going to be able to claim any money from Cynthia. Okay, so what you could do is have a go at writing that out and use appropriate case law to support your answers. So we're going to go on now to frustration. So if you think about what frustration means in everyday life, and particularly thinking about people who are learning a new skill, or young children, for instance, my daughter, when did she become frustrated? It's when you're unable to do something. And that's exactly what it means in contract law. If you're unable to perform your contractual obligations, it could be that the contract becomes void or automatically discharged. Okay. And in that instance, the remedies are going to be more limited because there is a lack of fault there. But we have to make sure that the frustration is genuine. Okay, so a contract may become frustrated, so unable to be performed, through three main reasons. So perhaps performance becomes impossible, or secondly, there has been a radical change of circumstances and the performance would amount to something very different to what was intended or agreed. Thirdly, perhaps performance becomes illegal. So you've got some cases that I'm going to show you here. So please read these cases and see if you can match these to those three, or what you think would amount to those three examples. So hopefully you've completed this, and I'm going to show you the answers now. So we've got performance has become impossible for Robinson and Davidson. Performance has become illegal for Fibrosis, Walker, Fairbairn, Lawson. There's a radical change of circumstances in Krell and Henry. There are quite a few cases coming out of this postponed coronation process, actually, which is quite interesting. And then finally, Taylor and Caldwell, again, performance becomes impossible due to the fire at the particular music hall. So hopefully that's quite straightforward. But of course, you could see where somebody might try to escape an accusation of breaching a contract by raising frustration. And it's for the courts to decide whether the circumstances amount to a frustration or not. And for you in a scenario, you'd need to make that decision. So I'll take you through some of the reasons why frustration maybe wouldn't apply. And I want you to take your time to read through the cases so that you've got those to support. So perhaps performance would be possible still, but just more difficult or expensive. So you can't raise frustration if you can still perform the contract, but it simply becomes more difficult or expensive than originally anticipated. There's a case here involving contractors against Fareham Urban District Council, and you see this situation quite frequently in contractors type building work cases. You'll quote an amount to complete some building works, and then it becomes more expensive. So you need that money. It doesn't mean that the contract is impossible to perform. It just means that it's becoming more difficult or expensive than originally agreed, and there has to be some adapting there. Maybe the change of circumstances is not sufficiently radical. And this is, again, another case based on the coronation being postponed because the king at the time was ill. Okay. Perhaps the impossibility was down to fault. As I said before, frustration will only be satisfied where there is no fault. It is out of your control. If you're unable to perform because you're at fault, something that you've done wrong, then that won't amount to frustration. And this case is really similar to the scenario that we'll look at. So please do keep an eye out for that. Impossibility might be foreseeable. So if you see it coming, what have you done to try and avoid it? Okay, because it's almost a willful frustration example then, in which case will not be a genuine frustration example. So the key is to identify what the issue is. Does it amount to a frustration, a genuine frustration issue or not? If you believe that frustration applies, then there are remedies available. As I say, it won't be a huge amount because it's a blameless scenario. But there is an act here, Law Reform Frustrated Contracts Act 1943. So any money already paid, for example, a deposit, can be recoverable, and any money already due would not be payable if a contract becomes frustrated. Compensation is discretionary only for work already done and expenses incurred. It may not be payable, so compensation may or may not be payable for any benefit which would have been acquired under the contract. So have a look here where I'm putting section 1, subsection 2, section 1, subsection 3. So these are the details that you could add in. If you recognise a frustration, you could then add these in at the end to advise the party what the remedies may be. So could they claim back any money they've already paid? Could they claim for any compensation and expenses occurred up until the event? A court-based compensation or any amount due on its merit, okay, and it's comes from a Latin term, quantum merit. So a claim is only really worth as much as it's been valued at, okay. So it depends on the quality of the work, and it would be for a court to perhaps hear from experts as to the quality of the work and what's been carried out so far in order to determine the value. Only if, though, the parties disagree on the value of a claim. If they agree, then this would not be needed. Okay, so final slide from me then. I'll leave you with a scenario. Now, this is quite an interesting scenario. Came up a couple of years ago with OCR, and students found it quite tricky because there's a lot of information. So you really do need to take your time and read this. It can seem quite complex. In essence, again, we've got 3 issues, and you need to identify whether the contract has been frustrated or not. So you've got a contract made by floaters, and they are a ship company, so they own ships and they contract those ships out to other companies to use. So they've made contracts with drillers, another company, choppers and boaties, okay? So there are 3 potential contracts here, and the best thing to do, and as I would always advise, is that you spend at least 5 minutes planning an answer before you write it, okay? So you'd need on your exam paper, never do it on a different piece of paper, on your exam paper, in your written answer booklet or on your paper where you're writing your answers, make sure that you separate out floaters with drillers first, floaters with choppers, and then floaters with boaties. Identify what the issue is and does that amount to a frustration or not, and then add in at least 1 key case, if you can, 2. Remember, for all scenarios, we're trying to aim for 5 to 6 cases ideally. Isn't always going to be possible, but hopefully you can at least add in 3 or 4 here, okay? So I'll just give you a summary. If you can pause and read this scenario first, and then unpause, and I'll take you through it briefly. So the first one, floaters and drillers. You could consider whether the performance becomes impossible through the super ship A that drillers were going to charter or hire sinking. Although consider the fact that the scenario says they haven't specifically contracted to use Supership A. They've only contracted to use a ship provided by floaters. So floaters could technically still be contractually obliged to provide a ship. So they could provide Supership B. The issue they have is that they've already chartered that out to somebody else. So are they in breach? So I would say perhaps the contract isn't frustrated. It isn't impossible to perform through lack of fault. Perhaps it just becomes more difficult or expensive. Perhaps floaters are at fault here. Okay, they're not able to give the other ship. All right. With floaters and choppers, consider that the contract becomes frustrated through a radical change of circumstances. So that's the fire, destroying the wood, negating the need to use the ship. However, again, you could consider this is quite similar here to the Crellin Henry, obviously the coronation being unable to go ahead because of the prince becoming ill, unable to be made king on the particular day. So we know that the man who was going to hire the hotel room was unable, that contract had become frustrated, so he didn't need to continue to hire. But consider whether home-based steamship could be relevant here. Perhaps they could still use the ship. Okay, I mean, they don't need it for the purposes of their original intention, which on the balance could make the contract frustrated, but you would gain an extra AO1 and AO2 mark at least for considering whether that actually makes the contract frustrated on the part of floaters. You know, it's not their fault. Okay. And then thirdly, floaters and boaties. So perhaps the contract becomes frustrated through performance becoming illegal. Okay, based on, as we're told in the scenario, the government forbidding trade to the particular country, that they don't tell us what it is, but that's quite straightforward, that last one. Okay, so you've got potential there to add in at least 4 cases, and my advice would be to give yourself some time to write that out. I hope that makes sense, and we're nearing the end of our contract law learning now, and I'll speak to you soon.